Attorney Kevin Cran with Cran Law Firm, and I want to give you some guidance if you are defending a deposition, meaning that you are having your deposition taken. Movies that involve depositions. One that comes to mind is a movie called The Social Network. You should watch that so you can know what not to do in a deposition, because in that movie, Mark Zuckerberg is very flippant, very insulting to the lawyers. So it's not a good example of how you should act during a deposition. But if you want to get an idea for how a very intense, larger than life deposition would look like, please take a look at that movie. Most depositions are not that dramatic. A deposition is simply a chance for the other side to take your testimony with a court reporter present. There's a court reporter, but there is no judge, there is no jury, there is nobody there that is deciding your case. How does it go when you have to appear at a deposition? Well, you show up to the deposition, whether it be virtually or in person, and a court reporter will swear you in, just like as if you were in court. Okay. Then, usually the other side will start giving you introductory instructions. For instance, the other side may tell you to speak up during your deposition, to ask for breaks if needed, etc. These are the types of standard instructions that they'll give you. After you're given a set of instructions, the other side will usually open up with softball questions. These are questions that are designed to get you to open up and to talk. They usually start with your background. So they may ask you, what was your highest level of education, and go from there. They may explore your employment history. They may explore any criminal history or any other lawsuits or civil actions that you've been involved in. It gets you talking. It gets you talking about subject matter that is fairly easy for you to freely talk about. After breaking the ice, so to speak, and getting you warmed up, that's when the other side will usually start getting into the claims, into the events of the case. So let me give you at least 10 tips right now so that you can be prepared for a deposition. And before I get into my 10 tips, I have to say that if you are pro se and representing yourself and you've gotten this far into your case without an attorney, kudos to you. But this is the part of the case where it is probably highly recommended that you get an attorney, because the other side, the person deposing you, is going to be an attorney. If for whatever reason you find yourself in a deposition without an attorney and you're looking at this video, then I hope that this helps. This video is something that I do give to my current clients, but I'm also their attorney who's going to be representing them. So let me give you 10 tips or 10 points of guidance that you should remember if you're at a deposition. Number 1, relax and be calm, okay? Avoid over emotion. There's no judge there, there's no jury, so just relax, be calm. Number 2, depositions are not trials. Your attorney may object to a question, or you may object to a question for the record, but usually the deposition still needs to proceed forward. Number 3, make sure you speak up clearly for the record, and make sure that one person speaks at a time. You don't want to be talking over each other. Number 4, confidential communications should remain confidential. Do not say, I told my lawyer this or that. Don't bring confidential materials to the deposition. Okay? Confidential materials between you and your lawyer should stay out of reach. Number 5, answer the questions concisely. If you feel like you've answered the question, stop. Don't ramble. Number 6, this is not a memory contest. If you feel like you've already explained your case several times in the pleadings, in the motions, in the complaint, in the discovery materials, in the witness statements, or in the statements you've provided, etc., etc. Don't feel like you have to rehash everything. If you don't recall an exact date, just say you don't recall the exact date. Or you can preface your responses by saying, to the best of my recollection, and then you can answer a question. Or you can say, I would need to refer to the document. Then it would be up to the other side to present you with that document to refresh your memory. So again, it's not a memory contest. Tip number 7, you still should be prepared for the deposition by reviewing the materials that you've already provided. If you've already provided statements in your case, such as affidavits, you need to re-review that so that you're consistent with your testimony. You need to review any discovery responses that you've provided. You need to review all of the documents that have been filed in the case, anything that's been submitted to the other side. So you should have a familiarity with your case, and especially anything that you've said, because the other side will already have reviewed all that as well. So that's how you prepare for the deposition. One of the first questions that will be asked of you is, did you prepare for this deposition, and what did you do to prepare? And you can always say that you reviewed the documents, you reviewed the case documents, you reviewed, any of your discovery materials. Be careful here, though, to not mention anything that's attorney-client privilege. Number 8, be comfortable with silence. If you've answered a question, the other side may be quiet and expect you to talk more. So just, if you've completed your answer, just stop. Number 9, breaks are permitted. So if at any time you feel like you need a break, ask for a break. If there's no question that is pending, you can ask for a break, a comfort break, a lunch break. Just ask for breaks as needed. Number 10, damages and remedies may be discussed, but settlement discussions are also confidential. Okay, they have no place in a deposition transcript, in my opinion, and that's just the general rule. However, damages may be discussed. When you filed your complaint, you may say, I am seeking this, I am seeking that. If you were terminated from your job, you may be seeking reinstatement with back pay. So it's okay to answer what is it that you want out of the case if you win your case. You can talk about what you expect to get from damages and remedies. Again, though, that's what you have an attorney for. So at some point in time, an attorney should object to the extent these questions are asking you for legal conclusions. That leads me to, I guess, my final point on that is that that's what your attorney is there for, to object to the form of questions, to make sure you're not locked into any way that you answered questions that may be formulated or that may be loaded, trying to box you in to say or misconstrue something you said. It's always good to have an attorney there to make those objections for the record. Those are my tips and my guidance for depositions. Again, I give this guidance to my clients in addition to consultation with my clients. This is for the general public as well. These are the basics. Of course, it's a case-by-case basis. You should always seek competent counsel when it comes to preparing for your deposition.